Hey everybody, how you doing? This is Mike McCormick with Advanced Criminology here in Owens Mills, Maryland. Today is February the, check it out, 16th, 2019. And tonight I'm reporting on the recent decision made in reference to the Korryn Gaines lawsuit filed by her attorneys, Mr. Kenneth Ravenel and J. Wendell Gordon, who represented her in her trial a couple years back. So let me kind of like update you. Those of you who follow the channel, follow me. I'm quite familiar with the case. It happened here in Baltimore, probably about 15 minutes away from my office in the apartment complex on Liberty Road. I will say this much: having read the judge's opinion, and the opinion again came down on February 14th. Judge Mickey Norman from Baltimore County Circuit Court is a judge who heard the arguments by both sides and rendered his 75-page opinion on this case. And as a result, the Baltimore County State Attorney's Office prevailed in their lawsuit, and both attorneys for Ms. Gaines have decided that they will appeal this case. So, having read that report, now, I'm not a lawyer for you guys who might think I am, and sometimes I think I am, but I will tell you, having read the 75-page report, and I have read a lot of briefs over the years. I have a lot of experience in contacts in the criminal justice system, particularly on the legal side. And so I'm quite familiar with how to decipher some of the rulings that I see. And what I don't know, I immediately go to the law books myself, maybe go to Black's Law Dictionary for some definitions and more clear understanding of what certain Latin terms might be or whatever. In this particular case here, the judge was quite clear from what I read in the documents. It just seems to me that the case that was presented to the jury was fine because it was based upon the preponderance of the evidence in the case. And so, when it came down to the appeal by the state, by Baltimore County, they actually attacked this case pretty much absolving the shooter, Detective Royce Ruby, or Corporal Royce Ruby. Basically, their argument and their defense was that he should have been protected under what they call a legal term called qualified immunity. And that's kind of reserved for government officials, acting in certain capacities, whether, they work in a government agency. That's not necessarily policing, but more and more you'll find that qualified immunity used in law enforcement when it starts coming down to use of deadly force. And so the judge probably spent a good 25 to 30 pages writing about why he agreed with the state in that her lawyers really never made a case that, in fact, Royce Ruby was not qualified. He should have been received qualified immunity. So I thought that was fascinating. I looked at some of the cases that the judge quoted. One of the cases, kind of the case that's always been like a primary case, what they call let the decision stand. In Latin, it means they say stare decisis. One of those cases would have been Gardner versus State. Tennessee versus Gardner. That was Tennessee versus Gardner, and that was a case that dealt with a Fourth Amendment violation, where a young man was breaking in somebody's house and he jumped over a fence and he was gunned down subsequently when he was running away actually from the police officers. And then the court overruled that and said that it has to be a situation where it involves felonies, so to speak, and that particular situation, that the individual didn't really present a threat to the officers because he was running away from the officers. And so he cited Tennessee versus Gardner, and he used the term a reasonable standard. What would any other officer do? Reasonable officer would have done in a certain situation, in that ruling in that particular case in Tennessee versus Gardner. So just to give you a backdrop of this particular case, on August the 8th, 2016, August the 1st, 2016, is when Korryn Gaines was shot and killed by the SWAT team. February 16th, 2018, there was a 3-week trial that was conducted here in Baltimore County. And at the end of that 3 weeks, the trial ended in a win for the Gaines family. And at that time, the jury rendered a verdict that the estate would receive almost $38 million. Okay, the state turned around on March 19th, 2018, and they filed their appeal. Okay, and this is what I'm talking about when I talk about the appeal. Let's get back to this. So I want to talk about that qualified immunity one more time. The judge said this. He said, requiring careful attention to the facts and circumstances. The jury was not asked to make specific findings. Now, some of the findings that the jury was asked to make were not necessarily pertinent to qualified immunity. And so because of that, the judge said, that because they weren't asked specific questions that they should have been, the court has to view the facts in light of the non-moving party. Well, the non-moving party in this case would be the state of Maryland. They're the non-moving. In other words, they didn't bring the action from the very beginning. Her estate brought the action. So they're defending the ruling of the lower court by saying, look, well, they're not defending the ruling. They're going against the ruling when they appealed it to the Baltimore County Circuit Court judge out there. His name Judge Norman. So the judge further went and said that, and which I didn't even know, so qualified immunity actually still applies regardless of whether the government official makes a mistake of law, a mistake of fact, or a mixed question of laws and facts. So that was interesting. I'm putting it out there where you're really going to have to, if you really want to get into this thing, you're really going to have to go to the law books to understand, what some of the legal parlance and jargon is and how things relate to one another. One of the things that was important that the judge brought out was that the verdict sheet was not clear as to whether or not the state was to pay damages or whether the federal government was to pay damages. And it's not his job to speculate as to who is responsible for those damages. And it was never on the verdict sheet. And that's something that her attorneys were responsible for and that they did not do. Let's see. So when I say that, they filed claims under the Maryland Declaration of Right, which was a state claim, and then they filed under 43 USC 1983 Act, which is a federal claim. Now, in the state claim, there's a certain cap of monetary damages that you can reach, and that's it. And in the federal court, it's unlimited. Okay, and so the judge is right to say, well, look, I don't even know which claim applies to what because it's not spelled out here in the verdict sheet. Okay, so he definitely ruled against that, or in favor of the state in reference to that. Let's see. Let's get back to okay. The Fourth Amendment applies for those of you who do know and probably do know. In this particular case here, it deals with what they call a seizure. A Fourth Amendment seizure of someone's body. In other words, if they went to the house to serve a warrant, that warrant is to seize your body and to take you in front of a magistrate. Okay, under the Fourth Amendment, they can do that. When Korryn would not come out, she basically resisted arrest under the law. Repeatedly, they asked her to come out. She still didn't come out. It's still resisting arrest, particularly lawful arrest, because there was a lawful warrant for a traffic violation. No matter how minor it is, it's still a warrant. And so that in and of itself kind of they met that burden in terms of the Fourth Amendment. Now, when you shoot and kill somebody, you've gone the ultimate that you could do to stop them or to seize them, so to speak, because now you've killed them and they can't go anywhere. And so the bar is a little bit higher in terms of articulating facts and circumstances that would lead a reasonable officer to believe that he would have to use deadly force to stop the threat. And this is what this case hinged on when I read the document, the brief written by the judge, is that it was never really articulated by her attorneys as to that's to the location of the officers in the hallway, and what the jury specifically, the judge was adamant. He said they specifically had to make determinations as to the threat in this particular case, and for some reason or other, her lawyers again were not as specific as they should have been. Let's see. And the judge said the test of reasonableness in determining whether qualified immunity is applicable requires careful attention to the facts and circumstances of each case. Excuse me. And again, that's found in Tennessee versus Gardner, right? He relied on another case in the Fourth Circuit. For those of you who don't know anything about the court system, legal system, when it comes to different appellate courts and things like that, well, the Fourth Circuit is located down in Virginia. I believe it's in Richmond, Virginia, and that circuit is responsible for reviewing cases that reach that from Maryland and some other surrounding states, and they review cases once you go through the proper procedure, the protocol to excuse me again. Once you go through a review of the appellate reviews, you have to follow in line and follow in suit the different courts, and anything leaving from Maryland, starting here, let's say the district court level, the circuit court level, the court of special appeals, the court of appeals, and then you go over to the federal courthouse, where you can file a writ of habeas corpus. You can file a U.S. 1983, and you can file that whether it's in local court like what they filed here in the district court, or you can file a 1983 in the federal court. And if you lose there, then that case gets sent down where in the Fourth Circuit as what they call a writ of certiorari. So I think I'm right about the process and how that goes. Okay, let's go back here. Let's see. The verdicts are defective because it did not specify a portion of damage. Defendant state claims. Okay, so a lot of folks will not like this verdict, and the reason a lot of us will not like the verdict is because we never really had all the information as to the case itself. We had bits and pieces. I reported on bits and pieces of this case based on some news media outlets, based upon my conversations with a couple people in Baltimore County. And that's how I reported on this case when I finally did put out a video in reference to this case. Simply because what we had heard was that, a couple of speculative things where she was not, she never fired a weapon, she was shot in the back. There's a few things that would really raise our eyebrows in reference to the SWAT team's handling of this case. The information that they had about her having mental illness. We knew that she had some issues with the police department prior to that day. We knew that she wasn't on her medication for over a year, according to her mom and people that close to her. We also knew that, quite frankly, when they did come with the warrant, that the first two officers that got there, the ones who said that they saw her with the shotgun. And they immediately retreated out of the home and then called for the SWAT team to come. There was more information in that document that I didn't even realize. I didn't know that they had spoken with her father. Father's the one who encouraged her to even buy the weapon in the first place. And they even knew that she was loading the weapon with birdshot, double-aught birdshot in the weapon. So, all that came from the family. And again, that was never reported. We never heard any of that, but it was clearly written in the document, and you feel free to go online and just PDF it, and you can take a look at it like I'm looking at now. So a lot of information was we didn't even hear about. What else? So when we look at the total circumstance of this case, this is a very sad case. A young lady lost her life, and I wish she had had somebody to really step in her life early on with some of the confrontations that she had with the officers, and maybe things could have worked out differently for her. Now, having said that, her attorneys have said that they will appeal this case. I can't wait to see the document they appeal. I can't wait to see what they actually do appeal, the points that they appeal. First of all, they have to overcome what they call, what I just talked about, the qualified immunity. See, there's no case. Once the judge ruled that the officer was under qualified immunity, that's their case. They lost the case at that point. Forget the fact that the apportionments of the money and whether it was related to the state action or federal action, that's not even important at that point, because the case hinged totally on whether or not Officer Ruby was to receive qualified immunity or not. And had the case been where he did not receive or could not qualify for qualified immunity, this would have been a whole different case, and the case would have been settled just that quick. And so that will be their burden on appeal. Her attorneys, that will be their burden. They have to overcome the qualified immunity. Having said that, I gave you the best I could give you under the circumstances of me knowing a little bit about the law, not a lot. If you have any questions, feel free, as usual, to let me know. That there's a box on the right hand side. If you're new to the channel, I'd appreciate it if you subscribe, learn a little bit more about what we do and what we report on. I'll be back to give you some more information on another topic. I haven't figured out which one just yet, but as always, we do appreciate your comments and your attention. Thanks a lot, guys.